Today's question is a pretty complicated one. When should you amend your H1B petition? Firstly, I want you to understand this video is not about short-term placements. Though we're going to touch on the topic, the video is primarily for longer-term material changes. We'll go over what material changes are, but we're going to start with the basics and then I'm going to get into my advice. It's a complicated topic because people have a wide range of opinions on the matter. While I'm going to offer you my opinion, I strongly encourage you to check with your attorney and your employer for case-specific filing strategies. If you don't already have an attorney and you need legal representation for filing your case, please visit our website at www.immlegal.com and give us a call. We're very excited to hear from you. Hi everyone, my name is Sachin Raval. I'm a partner at Ramchand and Raval where we practice immigration law. This is a fairly common question. Do I need to file my H1B amendment? Remember, the employer has to file an amendment anytime there's a material change in the terms and conditions of your H1B. A material change, for example, it can be a change in your salary, your job duties, your work site, your work hours, or your itinerary. So I feel it helps to start with when you don't need to file an amendment for you to understand when you should file an H1B amendment. Let's go over 4 typical scenarios when an H1B amendment is not necessary. Scenario 1, a change in the work location or work site within the same MSA. Now, by the way, what exactly is an MSA? An MSA is short for Metropolitan Statistical Area. It's an area containing a substantial population nucleus. Changing your MSA often means having new salary guidelines. Now, USCIS utilizes the salary guidelines issued by Department of Labor. Department of Labor requires that the H-1B salary be based upon the population salary in the MSA for that particular occupation. So what this means in practical terms is a software developer salary in Kansas City may be substantially different than the software developer salary in New York City. USCIS wants to know the appropriate wages that the employer should pay. How do you find your MSA? First, find the existing H-1B's labor condition application. Flip to the page that states the work sites and then Google. You can often find MSAs on government websites such as the Housing and Urban Development's website, or simply Google, you'll find some information about it. Now, to recap, remember, if you change work sites within the same MSA without any other material change, you don't need to file an H-1B amendment. Scenario 2, short-term placements outside the MSA that are less than 30 days typically do not need amendments. Now, this is a fairly complicated subject, and remember, this video is just touching on it. I want you to understand that this means that you're going to be working at your new work site, but for no more than 30 days, and you're going to return to the original MSA. Therefore, the original H-1B petition, and there's no other material change. An amendment is not required. Scenario 3. If the employee goes to a work site not listed in the H-1B application for no more than 5 to 10 consecutive days, you don't need to file an amendment. Also, if the employee is going for training or a seminar, an amendment is not required. The final scenario is if there are any corporate changes. So, for example, if there's a corporate name change, a change in the ownership, and no other material change, an amendment is typically not required. Now, those are the times an amendment isn't necessary. I'm sure many of you have come across this guidance on the web, but now let's get into my recommendations on when you should file an H-1B amendment. First things first, an H-1B amendment should be filed before the employee begins working according to the new terms and conditions of the employment. Now, you don't have to wait for that amendment to be approved, okay? Let's go over when you should file an H-1B amendment. So, if your job title, duties, or salary is materially changing, you should file an amendment. Remember, USCIS must ensure that you and the job qualify for the visa program. As such, you must file an amendment. Let's go over a real-world scenario. Let's say a software developer spends 100% of her time in development. But then she shifts to a more management-oriented job, and though the job is part of the software development lifecycle, it may be considered more of a management analyst or may require a much higher salary. As such, USCIS must be informed so that they can determine whether or not that job is a specialty occupation. Earlier, I had mentioned that you do not need to apply for an H1B amendment if you have a change in the work location or work site within the same MSA. I feel that this provision of the regulation, it's better suited for those individuals who are changing office suites or buildings or perhaps even campuses for the same employer with no other material change. However, if you're working for a third-party client site, I would take this advice with a grain of salt. Remember, if your job duties in your H1B petition reflect project deliverables for one end client, the deliverables and perhaps even the duties may be articulated in a different way for another end client. And if they're different, the safer option is to file an H1B amendment. This brings us to a discussion on peace of mind. I understand that the prospect of getting a denial with an H1B seems stressful. Frankly, getting the H1B approval on your initial H1B was probably challenging as it is. So I want you to understand that there are risks with not filing. I recently had a consultation with someone who was stopped by CBP and questioned about their job. Their employer opted out of filing an amendment, and CBP asked why he was no longer at the end client mentioned in the H1B case. He was taken into secondary questioning and ultimately was able to stay calm and explain about the new worksite. CBP asked whether the job duties had changed, and he answered no. They grilled him, and they asked him what is the likelihood of two different clients having the same exact job duties. He explained that this was in fact the case because his employer developed proprietary software for the financial services regulation, and that within the MSA, in fact, it was within the city, he was able to switch clients because of their software rollout. Ultimately, he was allowed entry into the US. However, imagine if his job duties were not the same. He could have been found to be working without authorization, violating his H1B, and ultimately denied entry. Now, this isn't a scare tactic. This is actually happening to people. So the consequences would be so dire that filing an amendment would have been an afterthought. So in general, I recommend filing an amendment because it provides the H1B employee and the employer something very valuable, and that's peace of mind. Now, if you'll notice, I use the phrase material change quite often. That's the language USCIS uses, but material changes can sometimes be subjective, and subjectivity often leads to varying outcomes. So let me make things a little simpler for you. If you have a doubt about whether or not something is a material change, you should definitely speak with your attorney. Have a consultation with your attorney, make sure your employer is on the line, and create a cohesive strategy, because that doubt you have will linger until your green card is in your head. So this reminds me, we have a short video geared specifically towards how USCIS even comes to know whether an amendment should have been filed. The link is in the description below. I strongly recommend you watch that video. It's very important for you to understand that even at the green card filing stage, USCIS will look to ensure you maintain proper H1B status. And filing timely amendments is a part of maintaining status in the United States. What if your amendment is denied? If the amendment is denied, and if the previous H1B job is still available to you, you can go back to that job, or you can file a new H1B amendment. In my opinion, there are more upsides to timely and proper H1B amendment filings than there are downsides. Once again, the peace of mind that comes with filing an amendment is invaluable, and that's why I recommend you file an amendment before joining a new worksite, having a significant salary increase. Remember, you can begin working based on the amendments filing alone. You do not have to wait for the approval. And that's it. That is the why and how and when to file an H1B amendment. If you found this video helpful, please like and subscribe. More helpful videos to come. Have a wonderful day.